But it also seems that her computer doesn't reverb, so we could just use her computer. The trouble is that the reverb on mine, even if it's on, I mean, even if it's muted, still seems to be doing it. Okay, so let's see. Is everybody here who needs to be here? Jessica, Joe. Oh, there you are. Sorry. Barrett, Tracy, LaTanya, Mitch, and what did you guys decide was going to be the defendant? Mitch, are you going to play the defendant?
Yep.
Oh, yeah, that's tucked in there. But now we don't have a defendant's attorney 3 listed.
Sure.
Somebody's got to be asking questions to the defendant.
Yes, I said that since I was doing the cross-examining, I could go ahead and ask the questions that I think Mitch wrote or typed.
Yep, you're right. I forgot about that.
Okay. All right. Okay. So I'm not too sure how to do this this way, but I think we'll just kind of go with flow. How does it work when you're over there? The reverb? Yeah, I'm going to turn myself off. All right. I'm just going to, mute it. Yes, but wait a sec. Wait until I unmute. Wait until I mute. So I'm so glad everybody was able to handle this. This is our first annual mock trial by Zoom. We'll try it again next time. Anybody have any questions before we get started? Somebody just, I haven't seen the video. What? Oh, no, you move wherever you need to. Okay, so hear ye, we're going to have this court come to order. And this is the trial between Walt Disney Studios and Eric Faden. And we will start with opening statements, and the plaintiff's attorney is Jessica Doyne, and she's going to start with her opening statement. And so, Jessica, I'm going to mute myself.
Can you hear me?
Yeah.
Okay. Ladies and gentlemen, let me start by saying we do not want to be here today. That's right. We do not enjoy bringing this case of copyright and Bad Wolf here to destroy Little Red Riding Hood. So just shut mine down.
I apologize, everybody. Yeah. Yeah, that way you can move your computer.
I just said, yeah.
Okay.
Ready? Ladies and gentlemen, let me start by saying we do not want to be here today. That's right, we do not enjoy bringing this case of copyright infringement against a college professor. We are not the big bad wolf here to destroy Little Red Riding Hood, Mr. Faden in this case. Do you all know what the vision statement of Walt Disney Company and Walt Disney Studios is and always has been? It's just 4 simple words: to make people happy. That is our goal, and it does not make us happy to be here today, and we are fairly sure it doesn't make Mr. Faden, the defendant, happy. But we have to be here. Walt Disney Studios has invested enormous amounts of time and money into creating movies for the masses to enjoy, both young and old. Now imagine having done all of this work, invested all of this time, and then someone comes and uses your work without your permission. Eric Faden, a professor at Bucknell University, uses copyright material belonging to Walt Disney Studios without express permission from the company. Though we encourage creativity and take pleasure in the fact that Disney's material has the potential to be used in this manner, because of the way the video was made and the potential inability for viewers to distinguish Disney's work from Mr. Faden's work, we believe that this situation holds great risk for Disney Studios. Mr. Faden, I'm sure, will claim that his actions should be considered fair use, that he was not attempting to render personal profit for the video, that it was only for educational purposes. I will explain why Disney's suit against the defendant for copyright infringement is a valid claim. In order for something to be constituted as fair use, the purpose of the use must be non-commercial, the material must be factual, the amount copied from the original work cannot be a substantial amount, and last but not least, the effect caused by the creation of the copied work cannot hamper the value of the original. Mr. Faden altered the original material to create a new video, yet his video does not fall under the transformative use law because he created his video by copying and manipulating clips of characters in Disney movies. Identical copies of the characters are used in his video. This gives the appearance that the plaintiff's copyrighted characters are stating an opinion about copyrighted law. The opinions expressed in it are not the express opinions held by Walt Disney Studios, and no permission was given that they could be used in such a way. By just glancing at this case, you might surmise that the creation of this video was non-commercial. Mr. Faden is a professor, and he was just trying to create a video to educate his students. But if you look closer, you are able to find places where Mr. Faden could make a profit off the creation of Disney's hard and earnest work. The video has been posted on YouTube, a social media platform that rewards its consumers, and if and when they reach 1,000 subscribers. A quick search on YouTube will reveal that Mr. Faden's video is at 933 subscribers, 67 subscribers away from 1,000. Though he has not received a profit yet, there is great potential for future gain because of Mr. Faden's indiscretions. It would have been very simple for Mr. Faden to request permission to use the material. A simple search would have led him directly to the Walt Disney Studios clip and licensing online submission form. If he had done this search, he would also have learned that alterations or modifications to the film clips or stills copyrighted by the plaintiff are not permitted without the express written consent of Disney Studios licensing. We will show you that while Faden used small clips, he gathered them from 27 different Disney movies for a total of 385 clips of Disney characters, a substantial amount in any estimate. We will contend that the clips do not fall under the category of non-commercial use. They are not being used for criticism or commentary. They are not transformative, and without close inspection, the video might be confused for an actual Walt Disney Studios product, and the views expressed mistaken for those of the company, which could be harmful to the copyrighted work. Ladies and gentlemen, by examining the facts, it is clear that Mr. Eric Faden is guilty of copyright infringement. On the surface, he might seem innocent, but as you delve deeper, you can easily see the wrongs that have been committed against my client. Mr. Faden will likely tell you that his video using the plaintiff's copyrighted characters falls under the laws of fair use. He might claim that we are trying to stifle innovation, creativity, and education by bringing this suit. That is not the case. First on the list of values and ethics in the mission statement of Disney is to foster and encourage innovation, just not at the expense of characters which were created to foster and encourage innovation. Just not at the expense of characters which were created, owned, and copyrighted by Disney, being used without permission to represent values not expressly held or put forth by the company. Imagine walking down the street and seeing a billboard featuring Mickey Mouse saying ban immigrants, or Snow White saying legalize marijuana. If copyrighted characters are not protected from being used to further the personal agendas, anyone might use them fair available for even one person to put words in their mouth. The purpose of their original creation might be lost forever. I stand before you today to ask that you put yourself in my client's shoes and imagine how you would feel if somebody used your work without permission for a purpose it was not originally intended. What Mr. Faden did is not right, and I hope that you will see it that way as well.
Thank you, Ms. Doyne. Do we have an opening statement from the defendant?
We do, Your Honor. Since time immemorial, mankind has strived to foster collaborative growth, each generation building upon the discoveries and inventions of its predecessors. The endeavor to work together, using the ideas of our forefathers and colleagues, has allowed us to reach intellectual heights that have increased exponentially throughout our history. Today, each breakthrough we achieve is the amalgamation of those that preceded it. Now, imagine for a moment that where we would be without this collaboration. Try to picture a world in which pre-established works cannot be utilized to advance scientific, creative, or scholastic discovery. A world where every great mind must develop ideas from scratch. Progress in academia, culture, and politics would crawl at a snail's pace. Law and philosophy would fall to redundant, fallacious disputes, and society itself would eventually crumble under the weight of its own stagnation. Ladies and gentlemen of the jury, you are not here today merely to evaluate the credibility of the claims brought against my client, Dr. Eric Faden, by the Walt Disney Company. No, you are here to define the scope and the strength of the protections provided to Dr. Faden by copyright law. You are here to further bestow clarity on the terms of fair use. You are here to make a legal statement that will echo for generations, one that can either enforce the freedoms given to artists, innovators, and teachers, or set a precedent of legal chicanery devised by those whose avarice outweighs all sense of posterity. Dr. Faden is an associate professor of English and film studies at Bucknell University. As an educator, his ultimate goal is to pass knowledge down to his students. Specifically, Dr. Faden teaches his students how to critically analyze influential texts through a variety of different media and examine their significance based on the cultural context surrounding them. As someone who works with a plethora of intellectual property, my client is naturally aware of the protections copyright law grants said property. However, he also knows the legal defense afforded to him by fair use. Now, the term fair use applies to a set of copyright regulations that allow critics, journalists, and educators like Dr. Faden to analyze, report on, and teach media without having to ask copyright holders for permission every time the works are used. Dr. Faden knows that educational and critical uses of media fall under the terms of fair use. However, his students are not always as knowledgeable on the subject. Aware of the importance of understanding copyright law in a class that studies protected media, my client created a video to teach his students about the legal rights of educators seeking to use copyrighted material. In his video, A Fair Use Tale, Dr. Faden uses small clips of films made by the plaintiff, the Walt Disney Company, to create a mashup parody comprised of lines spoken by Disney characters in their respective films. By arranging these clips in a specific order, Dr. Faden recontextualizes them into a new message that educates viewers on the nature of copyright law, fair use, and the public domain. Throughout this trial, ladies and gentlemen, you will be exposed to a myriad of legal terms used to enforce both the claims of the plaintiff and the defense of my client. However, I'd like to impart the four most important details you will need to know in order to accurately judge Dr. Faden's video as work that not only uses Disney content fairly, but epitomizes the rights granted by fair use. Number one, the nature and purpose of Dr. Faden's fair use tale. Number 2, the nature and purpose of the Disney films used in a fair use tale. Number 3, the amount of each individual Disney film used in a fair use tale. And number 4, the impact of a fair use tale on the market value of the films it borrows from. As will be established by both my client and my associates, the purpose of a fair use tale is clearly educational. The video is transformative, meaning it adds something new to the original work using a unique method of expression and conveys a method that is distinctly different from the works it borrows from. The plaintiff may argue that because my client's video is composed entirely of Disney-owned content, that the amount of said content does not agree with the conditions of fair use. However, any such claim is made entirely in bad faith. Not only is there no rule dictating the amount of content a teacher may borrow from an individual work, I and my associates argue that the clips used in a fair use tale are minuscule to the point of austerity. Dr. Faden used exactly as much content as he needed to form a coherent explanation of copyright law, fair use, the public domain, and his reasoning behind using Disney's clips, and nothing else. Finally, Dr. Faden's work does not undermine the intellectual integrity or market value of the original films. The parody has not affected the sales of the films it borrows from whatsoever. Furthermore, the work cannot reasonably be considered a substitute for the original films, even though it uses content lifted from them. Its purpose, execution, tone, rhetoric, and character are all plainly different from those of its sources. In the final chapter of A Fair Use Tale, my client uses his mashup parody to explain the crux of this case. Disney is an intimidating company. To borrow a quote from the video, if fair use actually works, then movies like A Fair Use Tale have legal protection. And if any company can take that legal protection away, then it may as well not exist. And allowing any one entity that kind of control over copyright law undermines the very checks and balances this case ultimately seeks to preserve. Ladies and gentlemen of the jury, your decision as to whether my client has legal privilege to use these clips will send a stern message, not just to Dr. Faden or his students, but to content consumers and creators everywhere. And in the name of education, of posterity, and of the free creative market, I ask you, I implore you to consider the impact that verdict will have. Thank you.
Just totally make sure that it's being recorded. Okay.
I'm not doing it again.
It's recording.
It says it's recording, so it's recording. Okay. All right. So would the plaintiff like to begin to call, would the plaintiff call his witness?
I'm present, Your Honor.
And the plaintiff attorney, are you ready to question the witness?
I am ready.
Okay.
All right. For the record, could you state your name for the jury, please?
My name is Mr. Jonathan Lovell.
Thank you. And your occupation?
I'm the assistant to the Director of Licensing and Marketing for Walt Disney Corporations.
And would you tell us what your understanding of the copyright laws are?
As we understand it in our dealings throughout the legal system, copyright laws are the legal protections of our intellectual property and our works against misuse by people who would seek to use them for nefarious or non-legally protected means.
Okay. And would you also explain to the jury what fair use is?
Fair use is a legal protection for creators to use copyrighted materials under certain circumstances.
To your knowledge, was permission sought or granted for use of this copyrighted material by the defendant, Mr. Faden?
No, in the weeks leading up to our decision to file this lawsuit as a corporation, we had our team go back through the entire records of our licensing forms, and there was no request, no form or submission requesting permission to use our works by any Mr. Faden or anyone from the university or the academic section there.
Okay. Is the copyrighted work used by the defendant nonfiction?
It is a nonfiction work.
Is it of a scientific, research, or political nature?
No, all of Disney's works are made with the mission of Disney corporations in mind to make people happy. So none of our works contain any rhetoric intended or inherent that's propagates any political, scientific, or research nature. Although some people like to interpret those meanings out of them, they are not the intended meanings or any intended purposes for our works. Our works are to make people happy and to represent a diverse culture.
Okay. And can you explain to the members of the jury how this video and the use of 385 clips of Disney characters from 27 different movies could be harmful to the original copyrighted work?
So our original copyrighted work is inherently attributed to our image as a corporation. We are our works. Our characters are present not only in the works that they use, but also in the theme parks that we operate, in our television series, and our promotional materials. So the use of these characters, not just the clips of our works, but the inherent characters that are copyrighted and protected under our corporation, is detrimental, because this video is using our characters, which are personifications of our corporate image, to portray a message that is not coherent and actually detrimental to Disney Corporation and our holdings. Dr. Faden, in his video, it clearly talks about the Disney Corporation and in almost a nefarious and derogatory light. And so the use of our characters, which are copyrighted, not just the movies themselves, but the actual characters, is detrimental to our corporate image and in the characters' images in and of themselves.
All right. So after that explanation and the way that you described the way that they used the video, would you say that there was fair use?
I would not list that as fair use, because it is detrimental to the market value of the copyrighted characters and works themselves.
Thank you so much. No further questions, Your Honor.
Would the defendant like to witness?
Yes, I have a few questions for the plaintiff.
Yes.
Mr. Lovell, how long have you been in the cartoon or movie making business?
So I am not actually involved with the production studio or the cartoon movie makers. I work in our licensing and marketing department, as I stated earlier.
But is it fair to say that you've had several run-ins with seeking copyrights of your materials or the materials?
That is what we do in the licensing and marketing division.
Okay, so like you stated, you are familiar with the copyright laws. Would you say that you are a novice or an expert in the matter?
I would like to think of myself as an expert. I don't think Walt Disney Corporation would have placed their trust in me if I was unaware of the situation.
Okay, in the area of public domain, Mr. Lovell, are you aware of how it's used and the
Yes,
limitations on the copyright?
So public domain is after a copyrighted material has been in the public for a specified amount of time that it enters the public domain.
So there are limitations on the copyright. Do you recall what those limitations are?
The limitations are the time limit set forth by the Supreme Court and the inherent meaning of the copyrighted material to the corporation. I'm not sure exactly what you're asking. Can we get back on track?
Yes. For example, if a person was to use the copyrighted materials for the news or for reporting or for parody or for teaching or for critical comment, would that be inside or outside of the limitations of copyright?
Well, the limitations of copyright would be more inherent on what can be copyrighted. Are you asking on the limitations of fair use?
Yes, sir. Fair use of the copyright.
Okay, I was just making sure that you knew what you were talking about.
I'm very clear.
Well, I was not clear about that. So fair use would be the limitations that copyright people can use copyrighted material. So it would be the amount used of the material, the intended purpose of the use of that material, the either commercial gains that could be used and attributed to the new user of that material, and what the detrimental impact could be on the original materials itself.
So the new use that Mr. Faden used to make the collage and the movie clips, would you say that was educational to the public?
I would say that it could be argued as educational, but that's only one of the four aspects that determines fair use. It's a whole aspect situation.
Okay. But what about the collage and the movie clips? Do you think that they are an exaggeration or a deliberate exaggeration or a parody?
I don't believe it's a parody. A parody is usually a taking of a work and using minuscule changes in that to portray a different message, but not conglomeration or collaboration or a collage of multiple works.
I would say that it performed a different message than the original work.
It would be a transformation, not a parody. There are some differences between those.
And would you say that the marketability of Disney's original was affected by his posting of his video?
Absolutely. Our market value is determined on the public image that we hold and portray to our public. So when our works and our characters are portraying an image or a message or a rhetoric that is counter to our corporation's public image, it is detrimental and it portrays our company in a negative light.
Do you happen?
By the multiple YouTube comments underneath his video that talk about Disney in a negative light and how that we're a horrible corporation, and it's absolutely a result of his video.
Okay, no further questions for the plaintiff right now.
So would the defendant like to call their first witness? I believe that.
Yes, I would like to call the defendant to the stand. Mr. Faden.
I'm here.
For the record, can you state your name?
Dr. Eric Faden.
Okay. And can you clarify what your profession is?
I am an instructor at Bucknell University in English and Film Studies.
Okay. And can you give us your understanding of the current copyright law?
As I understand it, copyright law deals with protection for intellectual property, ensures that creators are incentivized to innovate and create new works, and ensures that they are financially compensated for those works and are able to make a living off of them. That being said, there are limitations to copyright law to prevent monopolies on ideas, and I think that this case in particular, dealing with fair use, is a perfect example of why those limitations are in place.
Okay. And can you tell us what a fair use tale is?
I would call a fair use tale an educational parody film. It's also a critique of the Walt Disney Studios company's historical actions regarding copyright claims. overall, the point of the film was to demonstrate how using small pieces of existing works does not infringe on a mega corporation's ability to make money off of those works, but it does allow small creators like myself and my students to build on those ideas and actually share something with the world.
Okay, and can you explain to us why you made it?
So when a creative work like a movie or a book is protected under copyright, no one else is allowed to use that work without paying the original creator. A set of checks and balances, like I said, checks these exclusive rights, and that is called fair use. It allows others to use a copyrighted work under certain conditions. Generally, when used for criticism or news reporting or education, small breaches of copyright are allowed because it allows a more dynamic and an organic growth of ideas. Fair use, the way the law describes it, and to my understanding, involves the nature or purpose of the derived work, which would be a fair use tale. And the purpose of this work was education and criticism, both of which should be protected under fair use. Two, the nature and purpose of the original work, which were all animated films created by the Walt Disney Company for entertainment purposes. Three, the amount of the original work used in the derivative work, which, as we noted, was 385 clips over a span of just a handful of minutes. None of the clips were more than a second or two long. And four, the impact on the market value of the original work. And I would offer that perhaps Mr. Lovell is misunderstanding this fourth point. The impact on the market value of the original work, I think, is separate in the law from the impact on the market value of the firm that creates them. A fair use tale is in no way going to prevent people from going to see any of Disney's movies in a theater or renting it on renting it from a store, and that's where a problem would come in if I were making a copy that would detriment the use of that original work. And a fair use tale does not infringe on the owner's ability to continue to make money on those original works. And that's the main reason, one of the main four reasons why a fair use tale should be protected under the laws as they currently are.
Okay. So would you say a fair use tale is considered a fair use of copyrighted materials? And can you explain a little bit why, a little bit more?
Yes, I absolutely would say that a fair use tale is fair use under the laws as they are currently written. And again, the main point that was brought up by the plaintiff is that perhaps the work was critical in a way that detriments Walt Disney Studios' image. As a lawyer, he's undoubtedly heard of the First Amendment, which is free speech, and there's no law preventing me from criticizing a company whose practices I find unethical. And furthermore, like I said, none of the films that were used in the making of a fair use tale are at all detrimented or copied in a way that they can't be seen in their original state. And yeah.
Okay, so what impact, if any, do you think a fair use tale has produced?
I think that a fair use tale is a very important marker for exactly the reason that we're all here today. If without something like a fair use tale bringing to light the elements of copyright and fair use, there are plenty of people plenty of small creators who would be bullied around by a large company like the Walt Disney Studios Company while attempting to re-envision and build upon existing ideas. Creatively, culturally, it's very important for teachers to be able to comment on existing works, for other creators to be able to build on them, to reinterpret them, to criticize them. And if the Walt Disney Company is allowed to continually bully copyright lawyers and legislators into extending exclusive copyright protections for their work, we'll be edging on 100 years of legal red tape on the Mickey Mouse character, and that's preposterous.
Got it. So, in conclusion, you're actually saying that those mean old YouTube comments did nothing to diminish the value of the original work?
If the Walt Disney Company is at all threatened by a PhD professor from Indiana, I think they have other things they need to address.
No further questions.
Thank you. Would the defendant's attorney like to would the plaintiff's attorney like to cross-examine the witness? We would, Your Honor. So it's not needed, is it? No. Good afternoon, Mr. Faden. How are you today?
I'm well, thank you.
Thank you so much for coming today. I know this is challenging for you, but this is something that we must address and must handle. So
I understand.
my first question to you is, when you say that you did not bring harm to Disney, tell me in what respects you believe you did not. Your internet connection is unstable.
Say that. And I don't know that me bringing harm to the Disney Company is really what we're addressing here.
But this is the question I'm asking you. And
sure.
So that's the question that I'm asking you to answer.
Okay. I hope that my film is able to shed some light on practices by the Walt Disney Company that I find unethical. And if that harms their image in the process, I think that denotes an area of improvement for the firm, for the Walt Disney Studios Company. And I think you should see it as creative criticism rather than damage.
Okay, so now let me ask you a question. The copy that you all, the video that you all made. Now, I noticed something when I was watching the video. Now, what is your educational level? I'd like to ask you that, please.
I am a doctorate in English and film studies.
Very good English. That's very good. So then you do recognize, Mr. Faden, that if you are an English teacher, as you say, and I do believe you, then you know when you write sentences, one of the most important places that a sentence means anything is at the end and at the beginning. Now, when you look at your film, the beginning of your film is very dark until you get down to the end of it where it says Walt Disney and brings up the castle. And not only then does it bring up the castle, then it comes and it brings up the music that Walt Disney. Now, do you recognize that that is purporting that you are supporting and becoming Walt Disney? Do you not recognize that that looks like you are Walt Disney when you did that?
I'll pull up the actual video, but you undoubtedly undoubtedly noticed that.
Sir?
Can I do that?
I can't hear you.
Oh.
I want the jury to be able to hear you for the record, please.
Oh, okay. Yes. Hold on. Let me see if Dr. Madsen.
You could share the video if you wanted to.
It seems pertinent.
You know,
I'll pull it.
you're gonna pull it up on the phone?
I'm gonna pull it up.
I think Miss Williams is going to pull it up on the phone.
Yes, I'm going to pull it up.
Oh, he's,
Oh, great.
You're welcome.
So I think we'll note in just a second here the screen that you're talking about, if I'm not mistaken.
Yes.
you want to go to the end? You want to
It's
be at
it's
the
the
end.
very end.
And if we could actually pause it right here, we'll notice that before anything actually shows up that's related to the Walt Disney Company, there are three very...
Mr. Faden, you must understand now, I'm asking you the questions. And when I ask you to do something, that's what I need you to do. So I need you to go to the place where I am indicating, go back to the video where I'm indicating to you.
Oh boy.
Wait, what's happening?
Mackenzie, can we pause it?
Okay, now,
Oh, is it me? Am I?
okay, now I need you to back it up just a little bit because,
Sorry, that was me. I wasn't sure whose screen was showing. My bad.
yes, sir. Okay, so let's go back.
Is it me? Can you guys see me?
Okay, right there. Now,
So, yes.
okay, so I just want you to play it. You don't have to explain anything at this point. I just want you to play it.
Okay. Noted.
Thank you.
So you're referring to the Walt Disney signature,
Right here, yes.
yes,
But
and the three lines up above that, did you
No, sir.
notice them?
no, I noticed that, but I want you to continue to play. Now, when we looked at your, you can pause it now. When we look at your information, the last thing that we see is Walt Disney, and then we see the emblem that is the heart and the crux of Walt Disney. Now, understand that if your fair use cannot be the heart, you cannot use the heart of someone's work.
I don't know if that's written in the law anywhere, actually.
Well, it's written in our fair use laws, and it's written in copyright that you cannot use the heart of anyone's film, and that is the heart. When you brought up that emblem, everyone knows what that is. Even a baby who is watching the movie, if it's a Disney movie, they can relate it to Disney. Now, let me ask you something, Mr. Faden, please. Let me ask you something, just a moment. Now, I want to ask you, do you have children?
I don't.
Okay, but have you ever watched a Disney movie yourself?
Certainly.
Okay, so watching those movies, there are certain characters that you've seen over the years. Is that not true?
It's true.
Okay, and so then when you see those characters, what immediately comes to your mind? Does it come, do you think about fair use, or do you think about Walt Disney?
Well, when I was building this particular video, I was thinking about my message, but certainly when I am watching a movie, I'm watching it for its entertainment value.
Okay, for its entertainment. Now, there is a question that I have. Now, your Mr. just a minute, Mr. Lovell, Mr. Jonathan Lovell, he mentioned something that I want to go back, because since this is your product.
Yes.
Okay. Got a little, you know, this has been a day. All right, so what I want to ask you is, you said, okay, so the information that this is how I want to ask it. How do you see your how do you see your product? Is it nonfiction or is it fictional?
I am dealing with nonfiction.
Okay. So, do you know that? Tell me what you believe that the characters in Disney are.
I believe that the characters used in the films with which I built my video are fictional characters.
So if you built it on fictional characters and it's not real, then it does not fall under fair use. Okay, it does not fall. Did you
Tag 'em
know?
and tag 'em.
Did you know that?
I didn't know that, yes.
Did you did not know that? Did you?
Oh, I did, yes.
Sir?
I did know that, yes.
So if you knew that, then for you to proceed to continue to use fictional characters for your non-fictional product, don't you know you're violating the fair use laws and copywriting laws? Did you recognize that?
I suppose I'm slightly misunderstanding you. I think the point of copyright is that these works are protected, and that fair use allows me as a creator to use small parts of them, regardless of that use. I'm using them for education and for criticism. The fact that some elements are historical and some are fictional seems.
Okay. Well, let me just ask you another question. The nature of your film is nonfiction, but Disney's characters and everything else is fiction. So how can that be under fair use? Because these are fictional characters. They are not real.
Specifically because they are different types of media used for different purposes. That is what makes my work fair use of established work. If I were using your characters to tell another fictional story along the very same lines and taking great parts of your work in order to do that, that would toe the line. However, because I'm using small parts of your work for educational purposes, and they are doing different things, and as an educator, I am not infringing on your entertainment value. That is exactly why this video is fair use.
Okay, so let me ask you another question. Okay, now what are you going to do when you're on YouTube? Is that right?
The video is on YouTube, correct?
Right. And how long do you purport for this to be on YouTube? For indefinitely, or what's your thought about this?
I suppose anything that goes on the internet is there indefinitely.
Okay, so question is, now you're already on there, 933 hits that you have, or followers. When you get 1,000 followers, what happens then? Do you know?
Well, the video is listed as a Creative Commons license and will not be monetized. So no matter how many subscribers I have, I will not make any money off of the film.
Okay. But you'll get paid. You can. It is the possibility of you getting paid after you reach 1,000 followers. There is that possibility.
I could take that route.
And because that possibility exists, this is not fair use. That's a violation. That's commercial, and it's no longer for nonprofit.
is it not fair use for a news reporter to use somebody's name and get paid for their news story?
But are you asking the questions or am I asking the questions?
I think we both are. I
Well,
think that's allowed.
but that's not how we run a court. If I'm the attorney, you're answering the question. Oh, all right. Okay, well, Mr. Faden, I appreciate you for your time, but I do believe that you have violated copyright laws. Thank you.
Thank you.
So, Walt Disney Studios, would you like to have a closing argument?
We sure do.
Good.
Well, for nearly 100 years, Walt Disney Studios has tirelessly worked to build a family-oriented company that takes pride in creating wholesome masterpieces for children and adults alike across the world. The defendant, Mr. Faden, has taken advantage of the fact that Disney is a well-established company, which protects their work through the appropriate legal avenues. The defendant's educational video, the plaintiff was besmirched using their own movie clips for enforcing their rights as intellectual property owners. The defendant also used an unreasonable amount of Disney material to convey his message by unnecessarily repeating unaltered clips of copyrighted movies to sew together a message that was not approved by and does not reflect the opinions of Walt Disney Studios. Good people of the jury, we're not here today to quell the rights of creative expression. In fact, Disney inspires people of all walks of life to chase down their dreams. The plaintiffs simply plea for you to uphold their rights as the law dictates and prevent further damage to Disney classics that we all know and love. You have been shown evidence that a defendant's video has violated laws of fair use by causing harm to the Disney franchise through public opinion, which is the basis of our company entirely, by misrepresenting the plaintiff's values to consumers, and furthermore by gaining personal notoriety for manipulating the work of so many others who have toiled over 9.5 decades to create these movies. We plea for nothing but an equitable judgment from you, the jury, and hope that we have demonstrated the importance, the precedent this infringement case will set for all types of creators. Thank you. Well, I didn't hear you.
Do we have a closing argument from the defendant? Shin, you need to unmute.
Ladies and gentlemen of the jury.
We can hear you.
Okay. Ladies and gentlemen of the jury, there are certain elements of law that have to be violated as stated in Section 107 of the Copyright Act of 1976 before it can be found certain that Professor Faden has committed copyright infringement. The first element is the purpose and character of use, including whether such use of a commercial nature or is for nonprofit educational purposes. Professor Faden did not violate this element of the Copyright Act because he did not use the video for commercial purposes and he used it for educational purposes. The second element of the law is the nature of the copyrighted work. Once again, Professor Faden did not violate this element of the law because he used it for educational purposes. The third element of the law is the amount, the substantiality of the portion used in relation to the copyrighted work as a whole. Professor Faden did not show extensive amounts of clips of the Walt Disney Studios, and he did not violate this element of the law. The last element of the law is the effect of the use upon the potential market for or value of the copyrighted work. In no way would the contents used have affected the marketability of Disney's product. He did not break this element of the law. Therefore, my client has not violated the Copyright Act. Professor Faden created a video to aid his students in their English and Film Studies class for educational purposes. He only showed clips of the Walt Disney Studios videos. Since when has this been a problem? Professor Faden did not profit from showing the clips, and he did not show extensive amounts of the clips or claim that they belonged to him. The title of the video was even a play on words, A Fair Use Tale. This case is about what content is deemed fair use. Professor Faden was not using this content illegally. His video was a visual for his class to learn how to use content legally and understand what content is fair use. It is a bit ironic that the plaintiff brings a lawsuit against the defendant about fair use when that is what the whole purpose for the video is. How can we effectively teach students and ensure that they understand without visuals and examples? Faden's course and studies relate mostly to early cinema and digital image technologies. He created films, videos, and multimedia scholarships that establishes how research might appear as visual media. We believe that it is safe to say that Faden was only trying to teach his students and not mislead them as it pertains to the right of content and how to use it properly. The content used were not personal in nature or for profit. The viewing was mainly focused on teaching his students. It would be hard to fathom that a professor is guilty of copyright infringement by simply showing his clips or pieces of previous work. All the knowledge we acquire throughout our lives we share with others is not considered to be copyright infringement. Professor Faden's purpose was not for commercial purpose. In no way would the content used have been affected the marketability of Disney's product. And with that, ladies and gentlemen of the jury, my client, Professor Faden, has not broken the Copyright Act. Thank you.
So I believe that Laura, Kayleen, and Caden are all non-speaking participants tonight. And so they're going to be the jury. Kayleen, are you there? We don't see your picture.
Oh, yes, I'm here.
Okay, good. And Caden, have you come back from the dog saving? Not yet. I have created some breakout rooms. I think maybe the only one we really need is the jury one. So I'm going to assign. Oh.
For what it's worth, Your Honor, the jury as it is has 2 members for the opposition and only 1 for us.
Dear. You're going to have to just be.
Let the chips fall where they may.
Good thing we made such a convincing.
About to say, I mean, it's kind of fair. I mean, what is it going to be? A flip of the coin? One on one, one on the other.
So that would be.
That's some heavy injustice right there. I like it.
I put myself here. I guess we will be in here. So let's just see how it happens. So Kayleen.
Yes.
When you're in the breakout room, can you see yourself in the breakout room? Kayleen, can you hear me?
Yes. Is the breakout room on Slack or on Zoom?
No, it's in, I guess I don't know how to use this. Allow participants to breakout room. Open all rooms. So I'm going to join. All right. So Kayleen and and Laura and Caden, when he returns, are in this breakout. When is Caden returning? I'm not really sure. Sure, I don't know. So Kayleen, can you hear us?
Yes, I'm in the breakout room now.
Okay, so Kayleen, you and Laura get to talk. In the other, I don't know if the other people can, I don't know what's going on here.
Can anybody else hear us?
I only see my name now, so I think it's just us.
Okay, well, what's your thoughts on this farce?
Well, I would say, I mean, I feel like I'm going to sound biased anyway because I was on the other side. But
What were you on? The plaintiff or the defendant?
I was on Fader's side.
Okay, and I'm on the plaintiff's side.
And I mean, I would just say that Disney is still one of the top companies. Like, they're doing really well, and they're still a household name.
Well,
And
they're
they're
not personal, like that kind of thing, but like who made the best points, and like what, you know, that is, I think, like what we have to look at is all that, like, we were presented with. I think pretend that we don't know anything about Disney and what they're doing, but what were the facts in the case, and who said what and presented what, and which side made the best argument. Hello?
yeah.
So based on,
I mean,
yeah.
I think they both did a really good job.
Me too.
But and so it's hard to pick because they got, like, both sides, I feel like, had a lot of evidence.
Yeah.
Mm,
I don't know. We need Caden for a tiebreaker.
Go back to the main.
What do we do? Who breaks the tie?
Well, I think we can discuss as a whole group. Leave breakout room.
Would that be detriment to the market value of the characters themselves, not just the movies they were in?
Would that be like a whole separate case, or would it be like wrapped up real nice and pretty?
Well, I mean, it's still infringing on the copyright if these characters are copyrighted in and of themselves, so I think it would be the same. I just wanted to see if anybody else had thought about that.
I mean, I think about memes, right? And it's like you can use any character from Game of Thrones or, you know, the MCU universe and put them in a different context. And that's not infringing on, you know, Marvel's making money off of the movie, which
is it a violation of copyright that's just not being pursued, or is it not a violation? That's my question. Like, I don't know.
If it, especially with memes specifically, because that's non-commercial. Like, no one makes anything off of memes, or if they do, then I need to find out how to get that job. But I mean, as far as a meme goes, no, that's not a copyright infringement. But is, like, I know Disney for a fact has their original members copyrighted, and there was, I think, like in the mid to late 80s, a case where Disney sued, I think, the Oscars or someone who put a portrayal of Snow White dressed as Disney's Snow White would have been. But because Snow White was in the public domain, it got overturned because that's where it originated in the first place. Yeah. So they can't copyright something that's already in the public domain, but they can copyright their specific image of that character.
Yeah.
So it's kind of a difference. And of course, let's be real, since the trial's over, we all know Disney is like a monster when it comes to using their work, okay? We couldn't even watch Disney stuff in high school because of the copyright commissions and all of that. So having said that, I mean, let's think about it. Non-commercial use, I mean, you pretty much have to let it slide. I mean, what else are you going to do? Unless
commercial is just one of the four aspects. I mean, if you violate one of the four, you could still be in violation of copyright, even if it's non-commercial. So, like, it's kind of the whole image concept, not just you have to violate all four to be violating copyright. You know what I mean?
Yeah,
Right.
Like a
no,
lot,
entirely.
a lot of tests in the law. It's sort of a balancing, and it's not like a hard and fast.
I'm sorry, Dr. Matson, you're coming through really muted. I can't hear what you said.
Yeah.
That's probably the flowing. As Laura, what do you say?
It's like in our reading, it says that the laws have been left purposefully vague to allow a lot of leeway in interpretation of whether or not something violates it or falls under use. Why it's so hard to like nail down exactly what is what.
I definitely think on the commercial purpose use, Disney fails. I mean, Faden's purpose is so clearly educational, and he definitely does not make anything out of it, even though I think that was interesting that you guys noticed that it could have gotten to the point where he could make money, but of course he himself has no interest in making money.
Right, because that wasn't the purpose of his creation.
Right. The amount element seems to me possible. So,
That's what I was thinking, because the amount of footage he used, not that it's excessive in itself, clip to clip, but that there was a lot of repetition of phrases. So, like, I know every one of you watched this movie at least 3 times, okay? Like, we all watched it copious amounts of times, but there was a lot of repetition. It was just like the same ones over and over. And if it had been edited down, then, I mean, there would have been nothing to pick at as far as that goes. But
well, the fact that there's 385 characters, 27 clips.
Well, my question was just that, like, if you look at them as the characters being copyrighted, not the movies, then he used a lot of characters. So the amount of characters being used could be a higher percentage than the amount of screen time out of each movie. So I didn't know if that was a different way to frame it to try and win the case on Disney's part for the amount.
Yeah, so, I mean, obviously it's just a second or two out of any one movie, but the fact that it's so much of so many different parts, that I guess there's some chance, I think, for Disney to win on that part.
But I mean, out of if we're gonna make the case that, you know, Eric somehow damaged Disney as a firm's image, like what percentage of Disney works, like of Disney's total IP was used throughout this whole 10-minute video? Up 0.5%?
Yeah, I'm sure it's less than that even. So
A 0.5% of Disney is still more money than I make in a year.
Absolutely.
or have ever made, like,
Or
Or
will
will ever make.
But I'm wondering, is one of the issues, was it necessary to use that many? Because that's one of the questions as well.
I think
Was it
it
necessary
for him because he had to use all of those in order to get the words that he wanted to make his copyright message.
Well, you know what, it was difficult at first for me to figure out what he was saying because it was so repetitive. They kept saying, I'm like, what do they say? What in the world? What are they saying? And you could hear, eventually you listen and hear what the characters were saying. But it was challenging at first. And so I'm wondering if they had to keep,
you guys talk together now.
I wasn't sure if they had to continuously use those characters because it was repetitive. And even sometimes it sounded like they were saying once and twice.
because specifically he had, like, what would be a title, right? Like, what is copyright? And then he would go back and be like, copyright is, and keep going. And it was just, y'all get it.
So let me ask you this. Even if it was to be ruled that the use of the video clips was fair use, when he used the Walt Disney logo in the beginning, that was 100% of the logo. And if the logo is copyrighted, is that a violation of copyright that he used 100% of the logo?
Would you make, can you make the argument? I mean, what do you think?
So like if the logo was removed, then that's less of copyrighted materials that's used 100%. So then if the logo is removed, it would be less of a chance of it being a violation of fair use.
And less of a chance for it to be misconstrued as an actual Disney product. Because if somebody is not reading that, like, you know, brief notice and then just sees the Disney thing, they might think that Disney put that out.
Right.
Right.
Come on.
And
You can't be selective about what's there. If I put a notice in there, then you don't read it.
Yeah, even as on the
can't read that.
Even on the Walt Disney team, even on the Walt Disney team, I got to say that it couldn't be misconstrued as a Disney work because that was a huge blatant disclaimer up top. But the fact still remains that 100% of a copyrighted logo was used, and is that a violation of the copyright? Like, I mean, I can't just go throw in Nike logos on something that I make and say that it's fair use because I'm telling people that there's more to it than just Nike logo.
Like
the logo is copyrighted. Like you can't just use the company's logo.
Like a knot on top of the swoosh, like just not.
Yeah.
Don't do it.
I think
Just don't do
this
it.
is outside of my understanding, but I think we're treading now between copyright and trademark, and I think there's two different sets of laws that kind of determine use there.
There is actually, and the Disney logo is trademarked. It's not copyrighted. It's trademarked.
Also, the logo is trademarked.
Yeah, I don't know what the rules around that are.
I don't know.
But
okay. So what did you learn about trials from doing this?
I thought it was really interesting whenever Gwen was doing the cross-examination, how it got hairy with the who's asking the question. Because I mean, I remember being a police officer and being in court and trials as a witness for the prosecution, and anytime that I tried to fire back with a question at the defense attorneys, I got shut down. I can't ask questions as a witness. I can only answer. And so I thought that was really interesting how that played out here, you know, when there's not objections and rulings and interruptions to shut that down. I thought that was kind of interesting.
Yeah.
I mean, Gwen had a point. As a witness, you can't ask questions back. So I thought that was kind of funny to watch play out.
I think we missed out on the discovery process so that we could have the materials from the plaintiff's side.
Now, I have something that I want to read from the information that we have. Is why I went to the part. It says, number 3, the amount and substantiality of the portion used in relation to the copyrighted work.
Who's talking? We can't hear.
Yeah, that's really quiet. I can't hear what
It's
you said.
Gwen. She's at Dr. Maston's and she's not right in front of the computer.
Oh, okay.
Now, can everyone hear me?
I can hear you now.
Okay. It says the amount and substantiality of the portion used in relation to the copyrighted work as a whole. How much, and this is as a whole, how much of the copyrighted work did you use in the new work? Copying nearly all of the original work or copying its parts may weigh against fair use. That's why I focused on the heart. Because I
Right, so it's not the seconds out of the hours of the film, it's the heart of the message and the heart that those characters portray.
And that was why I pulled and kept pushing the heart, because that was against fair use. And I thought that was pretty important.
So let me mention that back to the trial thing. Gwen was right to tell you that you couldn't ask questions, but she was wrong.
Because I was arguing.
Because she was arguing. So her job is only to ask the questions. So she's supposed to elicit that stuff about heart and then the closing argument person is supposed to pick that up and use it for the closing argument.
Okay.
And see, I hadn't heard that heart argument yet. I had no idea, man. That impressed me. Just color me impressed, okay? Just like seriously, I had no idea where that came from, and like I'm sitting here like watching it unfold, and I'm like, this is getting hairy. Like, well, where is this going? Okay, well, my closing argument is very surface level, so just wing it.
So here's a position to throw out to the jury of a class. Dr. Mattson, I think I've learned a whole lot more in reflecting with the group in this discussion than I ever would writing a final paper. Could this serve, our wonderful group discussion, serve as a substitute?
Where you going with that?
Right? I like how this is heading.
There was no plan about that, was there?
Hey, you know, my daddy always told me the answer is no unless you ask, so.
That's a good point. Well, I'm not asking for a whole lot at the end. I just want everybody to, tell us a little bit about what experience. And there are 4 people, 1, 2, 3, 4, 5, 6, 7. There are 3 people not here, so.
Well, 3 papers to grade is a whole lot easier than a whole class.
That's true, that's true. Okay, yeah, okay, sure.
Wait, did I just get
Wait,
a sure?
that was a, okay, sure.
We got it on video.
It's recorded.
Got it.
I accept it. I don't want any more papers to write, really.
Do we have a decision from the jury or no?
No, I think it's in favor of the defense.
It's a hung jury. Wow.
So more important than the jury's decision, I just want to get some clarification. Is that you only want 3 papers to grade?
I'm sorry, what?
No, we don't have to write them if we were here at the meeting.
It cut up for me. Okay, awesome. I'm glad I asked that then.
And I think that, I don't know what Kayleen said. I know what Kayleen says. I think we're going to find in favor of the defense.
And Kaden
In favor of the defense?
Yes.
I think Kaden is still gone with the dog.
Yeah. Kaden.
Yeah.
That's okay. I'll just go crying to my dollar bills.
Everybody was really great. Everybody was awesome. But, you know.
We had a good time over here.
Yeah.
Man, y'all did so good. This was excellent.
All right.
I had a good time here.
Online. Thank you very much.
All right, well.
All right, bye.
Good night, everybody.
Good night.
Way to go, John.
Bye, y'all. Good job,
Bye.
everybody.
I did record.
Oh no, this is what you don't do.